Hello, everyone. This is World Arbitration Update, and we have an incredible privilege of being with these experts on dispute resolution panels. And before moving on, and I have missed introducing myself in the past, so I will not make that mistake. My name is Jose Antonio Rivas, and I am a partner at Extragy LLP here in Washington, D.C. And together with Ian Laird, we co-founded World Arbitration Update about 3 years ago. And the World Arbitration Update, or the WOW, has two objectives in mind. One of them is to update on issues of international arbitration, investor state arbitration, international commercial arbitration, dispute resolution, and also public international law. That's objective number one, because as you know, in today's world, in any of the major dispute resolution centers, in any of the decisions that is issued by arbitration panels or dispute resolution panels, etc., it would be very difficult to read them all. So we try to update the international community interested in these topics on those matters that have been happening for the past year or 2 or 3 years, depending on the subject matter. The objective, the other objective of not any less important, is to decentralize dispute resolution and international arbitration under the notion that that international arbitration and dispute resolution does not only happen in the main centers of the world, does not only happen in New York, or even in Washington, D.C., or Paris, or London. It is happening in many parts of the world geography, in Latin America, in Africa, in Asia, in other unusual places in Europe and in the States, etc. So we would like to give also a platform to individuals who are experts and who are rigorous and solid, who may come from other jurisdictions, and this is a perfect example. So we very much praise diversity, and here we are. So it is my privilege to introduce our moderator, who has been a force also behind the World Arbitration Update and Washington Arbitration Week, our sister event. Our moderator today is Margilis Jaime. Margilis is has several degrees. I would start by saying that she is a PhD in law, summa cum laude from the University of Paris, and she also has an LLM in international economic affairs, also cum laude, from the University of Paris, Panthéon Assas, and also an LLM in arbitration and international business law, also cum laude, from the University of Versailles. She's also an LLM from Georgetown. Second. Okay, we didn't lose the important part. But beyond her degrees, Margilis is a legal advisor at the Ministry of Economy and Finance in treaty-based investment arbitrations filed by alleged foreign investors against the Republic of Panama. She's a former trade negotiator for the Republic of Panama, having served as chief of the Trade in Services and Investment Department at the Ministry of Trade and Industries in Panama. She is also a professor of law at the University of Panama Private Law Department. And she has authored a wide range of publications in her areas of expertise and has participated as a speaker in a large number of forums internationally. Her latest short publication is a blog on Kluwer arbitration, asking the question whether the proposed multilateral investment court, namely by Europe, will really solve the unbalance of the investor state arbitration, or of ISDS, investor state dispute system. So as you can see, we have a wonderful moderator who is very much interested in topics that would allow dispute resolution go hand in hand with the notion of trying to finish projects, which are the dispute resolution panels. I myself, I have been a dispute resolution, panelist in the past, and that's what is most striking about this topic. Not only the idea of solving a dispute, but making sure that while you do it, you're not interrupting the infrastructure or energy related project that the parties initially agreed to complete. So with that, we're very grateful to each one of you. Margelis, you have the floor. Thank you.
Thank you, Jose Antonio. It's a real pleasure to be here again at the World Arbitration Update. Thank you also to Ian Layard and all the members of the organizing committee. It's really an honor. And in this case, as Jose Antonio was mentioning, so we're going to discuss about dispute boards as means to conclude successfully investment projects and resolve disputes. So as a way of introduction, dispute boards can be defined as permanent and sometimes ad hoc technical panels set up to accompany the parties during the whole performance of the contract and to assist them not only avoiding dispute, but also overcoming disagreements among them. So over the past several decades, dispute boards has emerged as one of the kind dispute resolution approach, in particular in construction and infrastructure industry, to efficiently avoid disputes and avoid the need to go to litigation and arbitration. We can cite, of course, several emblematic projects, such as boundary dam projects in Washington State in the 1960s. In Latin America, we have the first one in Honduras with the El Cajon Dam project. And also, of course, we can cite the UK-France Channel Tunnel project in the early 90s. And coming from Panama, of course, one of the biggest cases that we still ongoing is the expansion of the Panama Canal. And so after having, the dispute board, as you may know, we have now several ICC cases, and there's 2 parallel investment arbitration cases as well. So dispute boards have become also popular with FIDIC, as you know, the International Federation of Consulting Engineers, have included in their model contracts clauses referring the dispute to dispute boards. And also it has become a practice of the multilateral agencies such as the IDB and the World Bank. So to discuss this topic, we have 4 experts with us. I will start with Marion Smith. She has substantial experience as an arbitrator and advocate in complex international commercial arbitrations. She has particular expertise in construction, technology, and energy disputes, but also has handled matters across a wide range of industry sectors, legal issues, and geographical regions. She is one of a small group of female King's Counsel specializing in construction and technology disputes. Marion's standing in the profession is demonstrated by her service on numerous arbitrations and professional bodies, including the Bar Council of England and Wales and the Chartered Institute of Arbitrators. Marion, we're happy to have you here with us today. Our second guest is Jaime Gray. He's a construction law specialist. He founded NPG Abogados 20 years ago. He's a dispute board member as well as an international arbitrator. He has been involved in many leading construction projects in the region, such as the Pan American Game Lima 2019, and many segments of the highway in Central America, among others. He's currently president of Region 4, Latin America, of the Dispute Resolution Board Foundation. We have then Christian Diaz Barcia. He's one of the founding partners of Conexa Partners in Costa Rica and the director of the International Arbitration Practice. He acts as mediator, dispute board member, and arbitrator. He's the country representative of Costa Rica of the Disputes Resolution Board Foundation and the president of the board of directors of the Latin American Association of Construction Law, known as ALDEC. And then finally, last but not least, we have Luis Martinez. He is vice president of the International Center for Dispute Resolution, ICDR, which is the international division of the American Arbitration Association, and is an honorary president of the Inter-American Commercial Arbitration Commission. Luis is responsible for international arbitration and mediation business development for the East Coast of the United States, also for Central America and South America, the Caribbean, the EU, and the UK. Luis is also responsible for case administration of international cases out of the ICDR Miami's office. So with that introduction, let's get started. So to the point, and I would like to ask the first question to Marian. So if you could tell us in your experience, what are the main advantages of dispute board over other dispute resolution mechanisms, in particular in infrastructure and long-term investment projects? Marian, the floor is yours.
Thank you very much. Thank you for that generous introduction. And thank you also for that great scene setting with what a dispute board is. Let me just, everyone go in the chat, because I think that you've got such great speakers here. It would be nice for us to get a conversation going. I've just put a message in there saying where I am. It would be great if you could actually just tell us where you're currently sitting. Now, I don't want to know you're sitting in the kitchen. Baghdad, goodness me, I wasn't expecting that. What else? Where else are you? What a reach. Yeah, it's really interesting. If anyone else can get to the chat, just tell us so we can get a feel. We can get a good conversation going here. Anyone else going to be prepared to say where they are? That's a range. Were you expecting that range? Louis, I knew you.
Well, it's worth arbitration updates, so we can have people from.
That's great. I'm gonna keep an eye on that, and I suspect we all will. So if anyone's got any observations or questions or thoughts, put them in there, and we'll try and incorporate them into this and see where we get to. To come back to the question to me, what are the main advantages of dispute boards? Well, look, let me tell you the story. Why do they use dispute boards for the Olympics? In the United Kingdom, we have been a little reticent about using dispute boards. I would say, this panel will shoot me down if that's wrong, that we don't really use them in the United Kingdom, but we use them for the London Olympics with great success. And indeed, they were used for the Brazil Olympics. Now, why? What is it? Well, if you think about it, with the Olympics, you've got no room for delay. You've got no room for people to walk off site. You've got no room for it not to happen. It's just got to deliver. So it's very interesting that they choose and set up a dispute avoidance and a dispute assessment, a dispute decision-making scheme, and it becomes contractual and it's enforced. Now, why? What are the advantages of it? It makes sure you deliver. It makes sure that on that first day, when they light the flame, you've got the building. It's there. It does that for a number of reasons. Couldn't see Romania's come into the box now as well, and Mexico City. I love the juxtaposition of that. You've got, it allows you to bring in subject matter experts. I know that in this world, there is a belief that we are beyond experts. You don't need an expert. I personally think that's wrong, that experts help. And that what you can do when you're using dispute boards as your dispute resolution method is bring the experts in early. If you use your dispute board process correctly, you maximize the chances of avoiding the dispute or avoiding the escalation of the dispute. And disputes on site during the project are very, very disruptive. Human beings get diverted by disputes and they stop focusing on the build and they start concentrating on the dispute. Good questioning. Are they there to prevent or settle disputes? The answer is both. Both. And that's unique because by the time you get to a state court, it's about settling the dispute. What the dispute board will do at the beginning is it will prevent a dispute because it encourages communication. If you have set up your standing dispute board, and I'll be very interested in this panel's experience, does that happen? But if you do, and you set it up from the beginning, you've got experts who are kept in touch with the project. They get regular updates, they understand it, they're there as it's developing, and they can respond quickly as a problem arises. They can also, under almost all of the schemes, act informally. They give you an opportunity to vent, to just say, look, I can't bear him. It's horrendous. It's dreadful. Find me an answer. They also have the powers to actually go and ask. They don't have to sit back and be told, they can go and ask. So all of that could avoid the dispute escalating, could get it out of the way. If it doesn't, it gives you a quick solution. It gives you a, we call it here, pay now, argue later. That's the philosophy. Just get a decision. And frankly, for most disputes, what they want is a decision. It doesn't actually matter what the decision is, just cut through, tell me what the decision is. And you will get it in real time. You'll get it from people where you've maximized the chances that it's right. And you've probably achieved it at a low cost. I know that the industry believes that they're expensive. Statistics and data are difficult to find because it's confidential, but everything you find tells you they're not. They are very, very cost effective. And the other problem that's always highlighted is enforcement. But if you've got a real-time solution with a project going on, in my experience, enforcement is not the issue. Of course, they're going to operate it. They just wanted the decision. So my view is, based on my experience, is that they're a conspicuously successful addition to the range of alternative dispute resolution techniques. And I think they're sadly underused. I will shut up at this one. Is there anything else in the meeting chat? No. Let's see what else is going to come in and hand over and back to you.
Thank you, Marion. So you mentioned that hopefully we will have, the dispute board members appointed since the beginning of the project to avoid dispute. So Jaime, I would like to ask you, so how to select the dispute board members? So, and any practical recommendation that you could provide the parties when they are appointing these dispute board members?
Thanks for your question, dear Margie-Lise. I'm very honored to be part of this wonderful panel. And this has been confirmed after listening to Marion. I'm really, really glad to hear what she said. I would like to start by saying that the selection of dispute board members is of the utmost importance. As in arbitration, it is key to have the right arbitrator. In dispute boards, you also will need to have the correct and proper members are part of that panel. So from a practical point of view, I would recommend parties that they should identify the risks of their project, including technical, contractual, and legal issues, and then openly discuss how to define the respective profiles of the potential members. Within the characteristics and the specificities of the project, I should mention some of the relevant questions that deserve to be discussed. First, is it a complex project? Complexity, it's something which we should all bear in mind when discussing this important issue. It's not the same type of project. If you're going to build the facilities for a major sports events, such as the Olympics of the Pan American Games, or having a hospital or building a hospital, or why not a hydroelectric power plant, okay? Each of them will have their specificities that need to be duly considered and discussed. The second is, what types of technical disciplines of the project could generate disagreements or claims or disputes between the parties? I think that is very, very important. We will need to have a specialist in concrete or in geological matters, etc. Again, these are the types of things that are needed to be thoroughly discussed. Also, what type of contracts are the parties employing? Are they employing FIDIC, NEC, bespoke types of contracts? That should also be considered, in my view. And finally, are the parties sufficiently trained to properly understand and consequently use dispute boards? That's very, very important too. So that's it. Some of the characteristics of the members are, first, relevant experience in the type of project. They should have, they should also be part of a training in dispute boards and alternative dispute resolution. They should have experience as dispute board members, and also bring soft skills to the table, okay? Listening, that's very important. Going to the point, identifying the positions and the interest behind the position of the parties. Soft skills are key nowadays. And also, they should be, what I call being dispute avoidance focused professionals. Okay, yes, it is very important, and of course, okay, we will be deciding on the issues that the parties present as submissions. But most importantly, dispute avoidance. We should to focus ourselves on dispute avoidance. I will add today. I would like to add something additional. Dispute board members should be brave enough to say yes to the party who is right. Okay, bravery, be courageous. It's very, very important. And the lack of that important element, would be terrible. Practical advice, finally, and within the time that has been allocated, Margie-Lise. Okay, my practical advice is that parties need to be open and transparent when negotiating the appointment of the members. And secondly, they, should write, clearly what type of members they need. Please do not overestimate the profile of the members. Be realistic. Angels are in heaven only. Please take into consideration the dispute board members, market of your region. That's what I wanted to say. Thank you.
Thank you, Jaime. And Christian, so Jaime mentioned the importance of avoidance. And actually, I was looking at the comments that we have in the chat, and there's a question as well that it's like, why now we have these dispute avoidance adjudication boards, like a new kind of dispute boards. So I would like to ask you, in your view, so why should dispute boards and other conflict prevention tools be the standard to be applied in dispute resolution? So how, in your view, is important to put the point on the avoidance part of the equation?
Thank you. First of all, I would like to thanks World Arbitration Update and you, Margie, for the invitation to be in this panel with my dear friend Jaime, my dear friend Luis, and my future near friend Mario. So Mario, I'm reporting from Costa Rica, known as Paradise. So you will be happy to come here whenever you want. So, and I want to do 2 comments about something that Marian said and something that Jaime said. First, about the question regarding if the dispute board is for prevent or settle. And Marian said that is for settle and decide, which is true, but also to avoid. And to avoid is not just 2, not just settle and decide. You have to avoid, which is before settling. You know, the dispute board has to be 1 step ahead from the party to try not to have the dispute arise of the difference, because at that moment might be not a dispute, might be a different point of view. So if you try to avoid that before it's arising, you're gonna give a great opportunity for the parties to avoid disputes. So, and for that, we need a standing dispute board, which I'm gonna tell more about later on. Also, the statistics. I'm happy to say, Marion, that I have my own statistics, and it's 0.01% of the value of the contract, what the cost of the dispute board. And I have that from several dispute boards that I have been. So it's not official. I'm not the DRBF, but I can tell you from my experience that is way, 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 way less expensive than going to trial. And now I want to a quick comment also on Jaime's dissertation. First, he said, I don't know, he used this word, a dispute member has to be patient, passion, a big passion about dispute board, a big passion in construction law. If you don't have that passion, goodbye. You're not for this. Also, be ready to travel. Be ready to have dirt in your boots. We're not using clothes. We don't use ties. We use a helmet. You know, it's another story. So you have to be ready for that. You're not behind a desk, you know, in a nice suit. You're in that side of the works where it's rainy, it's cold, it's hot, and you have to be ready for that if you want to be a dispute member. Also, you get physical. You know, you travel in a van for 10 hours and go back to the hotel. This is a little thing that we had called in Spanish, lo que callamos los DAPs, what the DAPs don't say. So that is something that we're going to develop for the future. So going back to your question, I'm going to start the answer with an example. It's better to treat the patient rather than to do an autopsy to the patient, okay? So when we have a dispute board, we have the patient alive. If we go to another ADR tool, like mediation or arbitration, maybe we're gonna have to do an autopsy of the client, of the patient. So what we want, we want to do, treat the patient before he dies or she dies. So in 2017, FIDE includes a new A of avoidance in the DAAB, the DAB. Also, politics for the 2017 FIDE contracts address the party to have an standard dispute, understanding dispute board, which means that you're gonna be a dispute member from the beginning of the contract. So that makes a huge difference to have a dispute board from the beginning, from day one, well, from day 28, after the order or a initiation of the works, and to have, let's say, a standing dispute board at the middle of the contract, or just has an ad hoc dispute board to make decisions. And I will talk more about that in the next question that I have. So what benefits do we have if we have a standing DAB? Periodical meetings and visits to the sites of the works. So the DAB members, I'm gonna give you an example. In other contracts, the example could be different. What I do with the DABs that I'm at this moment, I'm in 4, 2 in Costa Rica and 2 in Peru. What I do is we have each month a call by Zoom like this. We have a drone that goes to the sites, and the engineers show us how the works are done. We have pictures, and we have a report of the advances of what happened last month, what is going to happen next month, what are the early alerts, and what are the possible claims between the parties. Okay? That is every month. The next month, we do a site visit. So we do the same, but on the site, and talk to the party, talk to the people that is there in the site, not to the managers of the companies. Okay? So that is a big benefit of having a standing dispute board, doing periodical meetings and visits to the sites. Also, when we do that, we have direct contact and communication between the parties and the DABs, and a kind of a relationship is developed with the representative of the parties and the dispute board members. So we become, let's not say friends, because we have, conflict of interest, but we become very close regarding the project. So that helps when you have to talk to the parties for a certain point of view that they don't have the same point of view. That give you more, a flexibility with the parties to talk about it and try to do a negotiation for that. And that also brings me to the other topic. The DAB can have what we call informal assistance, that the parties have an issue between them and as a non-binding opinion to the DAB, so the dispute board members give them opinion that is not binding for the parties nor for the dispute board, and with that the parties can decide and make a good negotiation. So from my point of view, the dispute board is more efficient for avoidance of dispute than other ADR tools, because the neutral party, which is the dispute board, is with the party in all the process of the contract, and since the beginning of the contract. That will be my answer to your question. Thank you.
Thank you, Christian. So, Luis, the American Arbitration Association, ICDR, recently revised the dispute avoidance and resolution board procedures. So, and we have been, listening on the importance of avoidance. So can you tell us a little bit more about these new rules and procedures, please?
I'd be happy to. Let me first start by thanking Jose Antonio and you, Margie, and WAU for putting the program together. It's a pleasure to join you and my distinguished colleagues here on the dais. So it's interesting for us, for example, last year in terms of the AAA and ICDR's caseload, We had over 3,700 construction cases domestically. We had 55 international cases. We are involved in infrastructure projects, working with several sovereigns. And yet we noticed that sharing Marion's UK experience, at least in the United States, they are not used as often as we think they should be because of the values that Christian and others have already described. And we had our dispute review board rules in effect going back to 2001 with little usage. So I'm in the international division. I work closely with our construction domestic division, and they have a very important advisory committee, the National Construction Dispute Resolution Advisory Committee. And we convened working with them and a panel of international advisors. And he said, let's look at these procedures and see what we can do in terms of revising them, promoting them, and seeing if they can be used more considering the caseload. And clearly, I mean, we hear from our users, the complexity, the long-term nature of these projects, it really makes it impossible at the outset to foresee every detail and external factor. But as an administrative provider, as we are not-for-profit, focusing on dispute avoidance, conflict management, and dispute resolution services, we wanted to offer these updated procedures so we can help parties resolve these disputes at the project stage. We want to focus on real-time resolution, and all the feedback that we receive from the users give us the tools, because we must keep the project moving forward at all times. And DARB procedures are one of those tools. So we did describe what they are, but I'll touch upon the way we approach them. DARBs, they're independent panels of experienced professionals. They're appointed at the beginning of a domestic or international project, really to monitor the progress of the project, and most importantly, help parties avoid and resolve disputes as they occur, almost as they occur, in a timely manner. I think their primary role, the way we've laid it out, is to identify and address potential disputes before they actually escalate into full-blown conflicts. They typically visit the construction site regularly, review project documents, incorporate technology to make their services more efficient, observe the projects. And I think one of the great tools is facilitating communications among those participating in the project by really proactively addressing these issues and concerns as they arise to foster collaboration and promote the successful completion of the project. So with the focus of the rules, we also vetted and developed a roster of domestic and international DARB professionals, which we have a standing list that we finished updating, and those are the people that we use to appoint for these particular cases. So quickly, just some additional bullet points on how they are appointed. The parties are free to agree on any method, but if they don't, the rules say that the board is going to consist of one member nominated by the owner, another approved by the contractor, and a third member nominated by the first two members, approved by both the owner and the contractor. And the third member typically serves as the chair unless the parties agree otherwise. And if there's any breakdown in the appointment process, the AAA ICDR will complete that appointment process. For a single member board, we have a list method. Each side is given 3 strikes. They don't have to give us any reasons. They number in order of preference, and they send that list back to us, and we use that list for that appointment process. Now, the board members must be impartial, not predisposed to any of the positions of the parties, independent, not have any financial interest in the outcome, and they have to disclose circumstances that perhaps are likely to give rise to justifiable doubts as to their impartiality and independence. If there's any challenges, we, the institution, will decide, and the main deliverables are they're going to receive reports and project process and meeting minutes throughout their role as an operational DARB. Now, in the event a dispute arises, there's several options. The owner and the contractor, they can refer the dispute to the board through either the interim advisory process. This is really a fast track proceeding. It gives the parties immediate verbal or written guidance on any issues to help them resolve the issue promptly. And it's one of the reasons why we incorporated avoidance in this new procedures. It used to be DARB. We're stressing to our DARB professionals to use all the tools available to them to avoid escalation and just keep it moving forward. The board's advisory opinion is not binding, and the dispute can later on be presented through the formal process. For the formal process, each party is given the opportunity to present its position in writing, and then if needed verbally at a hearing. Hearings are not always in person, although site visits tend to be in person, although we are talking more, as mentioned by Christian, about using drones, but there's still a discussion on how effectively that is of viewing an actual project through a drone. Promptly after the completion of the formal proceedings, the board provides written recommendations for the resolution of the dispute. Now, depending on the contract requirements or whatever the parties have agreed to, and I'm going to mention the three-party agreement later on, they can be either non-binding recommendations or they can be binding determinations until possibly overturned in a subsequent arbitration. And if non-binding, the recommendations may be designated as admissible or not admissible in any subsequent dispute resolution proceeding. If there's a designation, if there's not a designation, the default will be that the recommendation is admissible in a later proceeding, but not binding. And finally, if recommendations are not accepted by a party, the dispute kicks out to arbitration. In a domestic case, it's going to be administered by the AAA. We framed our construction rules as governing the proceeding. And if it's international, it'll kick out to the ICDR to be resolved pursuant to our international procedures. So that was basically our approach.
Thank you, Luis. It has been very informative and useful, to know better about the new procedures and rules. And maybe we have later to also that you could refer how to get into that roster. So, because I'm sure, part of the audience will be interested in knowing how to also get into the ICDR roster. So but before that, I would like to go into more practical recommendations, and I would like to ask Jaime. So if you remember, Jaime, so Christian started mentioning, well, the visits, right? So I don't know if you could have, practical recommendation to either go with virtual or in-person visits during the project. Of it depends on what the type of project, and any other recommendation that you could give. For example, would you recommend advisory opinions outside of the DB members? So the floor is yours.
Thank you. What an interesting question, Margie-Lise. Firstly, let me say that I really think that visits are the most important tools for avoiding disputes. That's my view, and I think that Chris will agree with me. Why? Because during these visits, the members become acquainted with the parties and the members of the staff of the parties, and that's very important. That's a personal type of thing. The members also become familiar with the site of the works, and that's also very, very important. And they all discuss the concerns of the parties. Okay, parties present not only the claims, not only the dispute, but the concerns, and that's again very, very important. okay? And I think that the members have during a visit, they have the perfect opportunity to help the parties identify potential disagreements and how to resolve that. And that's simply priceless. Also, in-person visits are an efficient way to generate trust and confidence between the parties and the members. And confidence is built out of human relationship. And again, for that, being there, and shaking hands, it's, a must. During these visits, people meet, listen to each other actively, not passively. They commit, they share personal experience, and why not, they laugh together. Okay, we're human beings. Again, we're human beings. That certainly help parties to resolve the unresolved issues they may have. Sometimes the members of the DAB request the top representative of the parties to ride in the same bus with them in order to generate camaraderie and again, trust. That's, again, very, very important. And sometimes when you call the top representative of the parties, to go and to ride in the same bus, maybe you may have the intention to separate these decision makers from their staff, as it would be perfectly normal that some guys who are members of that staff probably opposes to finding a good solution. And let's remember that a good solution is not necessarily a perfect solution. Let's leave the decision makers alone with the members, and they will find a good solution for the project. That said, in my view, an in-person visit is irreplaceable. Okay. However, for follow-up meetings, I think that it is very efficient to have virtual meetings, as the cost of an in-person visit involves logistical expenditure, flight tickets, hotels, use of cans, transportations for the members and the parties, etc. Okay, we can also use, as Luis has said, drones, and that's very, very efficient. But that's, in my view, again, for follow-up meetings. But the most important events occur during the visits. Now, regarding advisory opinions are necessary when both parties request the members to do so. So let me say that the members should be very inductive. They should lead the parties to find the issues and propose how to resolve their differences. And in my view, I think that ask questions, know how to interrogate. It is very, very important. And yes, it's an excellent way to be inductive. Okay, don't be affirmative. You as a member should be very careful, not affirming things. Okay, you should take advantage of the richness of the language. Okay, and again, ask question is a perfect way to be inductive. And advisory is a wonderful thing, as Chris has mentioned. Okay, we are there and we will be happy to help the parties. Thank you, Marjolise.
Thank you, Jaime. And I would like to turn now to Christian again. So you're an experienced dispute board member. So do you have any success stories to share with us? Do you think that dispute boards in standard form contracts are the key of the success?
Thank you. Before going to your question, I just want to add something from the comments that Jaime. My comments is visits to the site are very important. especially if you're in a dispute board in Peru, because lunchtime is great. So, but besides that, besides having the greatest food in the earth, seriously now, you have, as Jaime said, you're in lunchtime, and you talk to the managers, what restaurant we should go, and the manager say, wait, why don't we go here and the other, and they start doing this in compass to each other, and they get an agreement on what restaurant to go. You know, that's a way for getting the parties together. And then you go to a restaurant and you sit next to one manager and next to the other manager, and there you don't talk about the project. You know, you build this trust, this relationship between the DAP and the parties. So that's a comment that I want to add from a dissertation from Jaime. Okay, so I have the blessing to be in 3 countries in DAPS. One was Salvador, one is Peru, and one is Costa Rica. So I'm gonna give you my some histories, some things that have happened in those countries, and each one have a different contract, a formed contract, a standard contract. In El Salvador, we have the Millennium Initiative. In Peru, we have the NEC contracts, NEC, as we say in Spanish. And in Costa Rica, we have the FIDIC contracts. So I have experience in all those 3 different standard forms. In all of them, we have dispute boards as part of the ADR clauses. So I'm going to tell you some stories about each country. First, in El Salvador, which was my first experience some years ago, I was acting as a legal consult to a Spanish company that was the builder, you know, the contrast. And the experience that I have there was that the dispute board was meant to be an ad hoc dispute board, which is better than nothing, but it turned out to be a mini arbitration process, which is not the meaning of a dispute board. So my learned lesson there is that you should have a standing dispute board, not an ad hoc dispute board, because what an ad hoc dispute board will do is make a decision about some dispute, but that don't help in avoiding this dispute. So that is the history that I have from El Salvador. Then in Costa Rica, I have 3 experiences. One as also an ad hoc dispute board to draft a decision. The good thing is that decision was settled between the parties afterwards. So it helped the parties to not go to arbitration, which is good. And the other one, which is, I think, one of my best experiences in my short history in dispute boards, is I am a sole dispute member standing in the border from Nicaragua, from Costa Rica and Panama, the border facility. We started 1 year ago. Since day 1, I was there, and there was no one dispute given to the DAP. All the differences between the parties were settled between them with a huge effort from the engineer. FIDIC has the engineer tool, and from the dispute board member. So, and the contract is already almost finished, 1 month away to be finished, and no one dispute, no one. So that is another statistics that I can say in my personal experience, that dispute boards works for avoiding disputes. Then in Peru, I I serve as dispute board member in 4 dispute boards there. Most of them, we have settlements in many disputes, so that is really good. But one of the greatest story that I have is we were in the hearings, 3 days hearings, and in the middle of the 3 days, the parties stop us and say, I think we have an agreement. Let us work to this afternoon, and by the end of the day, we will send you our settlement. So, and for us was great, because that means that the main purpose of the dispute war was achieved, you know. So just to finish this question, I want to talk 1 minute about the efficiency on time and costs. So with the dispute board, you have the project finished mostly in time and in costs. The cost is way lower than going to a judicial process or arbitration. But more important of the cost, let's forget about the cost. Let's forget about attorneys and engineers. The most important is that dispute boards are used in infrastructure projects, such as schools, roads, ports, hospitals, etc. And so those infrastructure projects are a driver for a country's economies. So the DAP should be a key tool of the development of the countries for that purpose. Thank you, Margie.
Thank you, Christian, for sharing those experiences. So now I would like to turn to Luis. So Luis, you started talking about the different options for the parties. So between recommendations, binding recommendation and non-binding recommendations. So I don't know if you could talk a little bit more about that, and perhaps some other innovations that are in the new procedures rules. In particular, you know, something that caught my attention was the consolidation or the possibility to consolidate different disputes in just one. So maybe you can take, you know, a word on that. Thank you.
Sure, and thanks for the question. Yeah, let's obviously we've discussed certain options and certain approaches, and hearing Christian's experiences. It really all starts with a properly drafted 3-party agreement. And you know, you need to know the project. You need to know specifics about the governing law and issues that can arise before you really sit down to say, I want to use a DARB for this particular project. And remember that the board that's going to be convened is also a signatory to the 3-party agreement. It's owner, contractor, and the prospective board. And under our procedures, they have to execute this within 14 days after you completed the appointment of the 3rd member of the board. But obviously, thinking about how to approach the agreement and the board and using them in the first place, you have to give ideas to some of the things that you want to include in the 3-party agreement, which will govern and give the authority of the DARBs as they begin to operate. So as I mentioned, overview of the project, what is the actual specific purpose of the agreement, their terms of reference, if you will. I think it's important to lay out another of the options is to consider what is the scope of these disputes? What type of claims related to the project is going to fall under the purview of this particular DARB? And that should be listed clearly in the 3-party agreement. Now, keep in mind that our DARB procedures covers a lot of issues where if the parties do not agree or do not specify it in the actual 3-party agreement, like the appointment, the rules do have default mechanisms, as it's the same way you use arbitration and mediation. You can use a short clause, and the rules have all the default mechanisms needed to keep the project forward. But you may want to discuss how the DARB will be composed, how they'll be appointed, what are the qualifications, experience, expertise. You can list that in that three-party agreement. You also want to perhaps specify the hearing location, the seat, if you will, for these hearings, if they're going to be conducted in person. And what changes, and looking at our DARB procedures, you may want to opt out or opt into. So you want to may customize it for the sake of that particular project. Costs and expenses are an important issues. If they're not addressed specifically in the three-party agreement, but they incorporate our procedures, it is listed there that the costs are going to be shared equally. I think governing law is important. The dispute review board people, professionals have to consider the governing law when they're rendering these opinions, and perhaps in how they're discussing them in person later on and giving an overview of, listen, if this is not accepted or this escalates to arbitration, this is some of the things you need to consider with the application of this particular governing law. You may want to also put verbiage in there, how it's going to be terminated or suspended. And then really, as we've all seen, other impacts to supply chain issues affecting projects, force majeure, pandemics, etc. Do you want to include any verbiage to deal with the extraordinary and the unexpected? To me, I think if you really have experienced people, we also recommend, obviously, legal counsel look these over, but the board professionals as well that are going to be experienced are going to know what terms and what's needed for the three-party agreements, as well as the owner and contractor. So it's a great tool that has to be carefully executed, and I think that adds a lot to the possibility of convening a DARB that's going to meet the expectations of all, and again, keeping the project moving forward. Now, you mentioned consolidation. That's in our international rules and our construction rules. We do have a clear verbiage on how, if we have, and that's when it's used in these types of construction cases with multi-party agreements. You may have subcontractors. There may be verbiage that links certain contracts to the general contractor, subcontractor. If the parties do not agree, we actually, pursuant to the rules, can appoint a specific consolidation arbitrator. What is needed in the pleadings is included in the verbiage of the rules, and that arbitrator is going to make a decision whether to consolidate or not. If there's separate tribunals already in place, which tribunal will continue, under what rules, at what stage. They make all the necessary determinations to have a successful consolidation and proceed under one case when it meets the criteria of the rules. Now, having said that, it's also not it's not used that much at all. We revised that part of the rule, was actually included in 2014. We revised our rules in 2021, and I think maybe there's been a handful of cases. So the consolidation issue, at least under our experience, doesn't happen that much, or they may agree beforehand and you don't need to actually go down the road of appointing a consolidation arbitrator.
Thank you, Luis. And on the question of the roster, so how does it work?
Absolutely, and it's quite simple. Send me an email, if you don't mind, martinezl@adr.org. I'll put it in the chat. We review it every 6 months. I'll respond and give you some of the criteria that we had asked people to provide us regarding their experience and work with DARBs. And then I get together with my construction brothers and sisters, and we make a determination, usually twice a year.
Okay, well, thank you. That is also informative for the audience. So I will turn now to Marian. So dispute boards, Marian, do you think they could replace or help define arbitration as a dispute settlement of last resort?
Okay, let me explain. I'm going to give you the answer yes, and I'm going to look at two aspects of it. The first reason I say yes is I look at what has happened in common law jurisdictions with the use of adjudication. Now, adjudication is to deal with dispute decision-making. So it looks at the second part. It's nothing to do, not nothing, that's an exaggeration, but it has little to do with dispute avoidance. But what adjudication offers, and it is imposed, it's mandatory in the United Kingdom for construction contracts. And it imposes the pay now, argue later regime. It offers for all construction disputes a mandatory right to take the dispute to adjudication to get an interim, temporarily binding decision. I sit very regularly as an adjudicator, and you have 28 days from appointment to decision. It is very, very focused. And it has been a huge success in the United Kingdom. And it has, if I may use an exaggerated word, it has killed domestic construction arbitration. There simply are none. Again, it's an exaggeration, but it makes the point. Parties take the decision of the adjudicator. They accept it. It's good enough, and they move on. So I think dispute boards, DAABs, whichever form you talk about, have the potential to achieve this. They really do. And there was a good question in the chat box. Someone said, look, FIDIC has introduced a dispute avoidance adjudication board. Kindly explain more to which other contracts this will be effective. Now, I hope that the clear message that's come from all of us is every single contract. I think it's a concept that you can take and apply in a huge range of contracts, where especially anything that is long-term, where you're more about keeping the deal together than it is about a short-term profit. So I think that it's used, as Christiane was saying, in the NEC, the ICC have standard terms and provisions, the IDRC have, almost all of the big arbitration institutions offer their standard rules as well. So parties can take it and adapt it. And that's why I think the second aspect I want to look at, which is that dispute boards are part of the even more important prior contract, which is the multi-tiered dispute resolution clause. And I think that that is something that we are seeing increasing use of throughout the big construction and infrastructure projects. I think it's parties sitting down and asking themselves the very, very basic question, how do I fit the forum to the fuss? That's the expression that's used. How do I fit the forum to the fuss? Where are my disputes going to arise, and how do I want to resolve them? And in that escalation process, the dispute board has a very clear role to play. I think multi-tiered dispute resolution clauses are here to stay. I think dispute resolution boards are here to stay as well. And I think that they're not picked up enough because you don't have enough sessions like this, getting that message across. And when you've got people, like this bunch of committed dispute board professionals passionately explaining what it gives you. We're not angels, but we avoid having to resuscitate the devil, the dead patients. It gives human beings a way to actually focus on what really matters: improving society, getting the road to the hospital, making sure that bridge is there. So I think it's here to stay. I hope it's here to stay. And enough. What do you all think?
Thank you, Marion. And with that, we still have a couple of minutes. So what I will propose is to take, 1 or 2 more minutes for concluding remarks from each of you. So I may start with Jaime.
Thank you. I will start with 3 words only. Use dispute boards. Okay. Yes, because beyond, theoretical issues in which we could thoroughly discuss for years, I think that from a practical point of view, they have already demonstrated that, they really work. That is why I said that, okay? They have been employed, as Marion has said, in the Olympics in London, and they work. They were here in South America with a project called the Pan American Games Lima 2019. And again, they work. And they even work in my country, in Peru, in the general regime of public procurement, which is really a nightmare, okay? And they are working here. So that said, I can only encourage all to use dispute boards. And that's how I would like to conclude my presentation, dear Margie-Lise.
Thank you, Jaime. And well, we have in Panama the Panama Canal expansion as well, because otherwise we wouldn't have a Panama Canal, finalized. So, Christian.
Okay, first, I'm gonna give my first provocative comment. Where's the engineer? I don't see engineers in the panel. I see that, for instance, Luis Fukunaga, which is a really good dispute board member in Peru, is in the audience. But remember, dispute boards are not for lawyers. We are an invited party to the show. Dispute board are for engineers, and we can help them a lot. But we're missing engineers first. This is my first comment. And my second comment, dispute board and arbitration are two different things. You cannot mix them. One is for one thing and the other is for another thing. They don't compete to each other. Dispute board is good for something and arbitration is good for something else. And both can coexist. So we had to try not to put them against each other. And thank you for the opportunity. I have a blast. Let's talk for one more hour, please.
Thank you, Christian. Luis, please, your turn.
So as I've been saying, keep the project moving forward. And I do agree with Christian that DARBs are quite different from arbitration. The arbitration is the fallback mechanism should anything fail at the DARB level. But think of the efficiencies of having these dispute board professionals at the site, the relationship buildings, the knowledge of the project. They are there to diffuse issues as they arise in real time. They are going to be successful. And it is important to have more conferences like these, as Marion mentioned, and to keep getting the word out of their value, because we're in the conflict management and avoidance business. And this is a tool, when properly set up, has value and works. And you don't have to get to the arbitration stage, because think about the knowledge and experience that the DARB professional has with the project, as opposed to not reaching a settlement or not having them in place and having to tell our panel of arbitrators and educate them not only on all the issues and the claims, but also the project itself, the governing law. It is just so much more efficient to have the DARB in place, especially in large international infrastructure projects. So keep the project moving forward.
Thank you, Luis. And Marion?
May I have a plea? Data. Data, data, data. I know I've got dispute board senior professional representatives here of the dispute boards world. Data helps. We need to be able to put in front of some very hard-nosed finance directors, what's in it for me? What's the bottom line? We need the official stats. I know it's difficult. I know it's a confidential process. It's a private process, but if we could get the data, it would make a difference. And the only other pragmatic note I want to say is we have to recognize that there's enormous pressure on the state court system globally. Enormous pressure. And to an extent, there is enormous discontent with the state court process. And this is a prime opportunity to offer dispute boards as a resource that will resolve disputes for parties, take the pressure away from the courts, and ultimately give them a solution that they will trust. And that is a very powerful piece to offer in this riddled with doubt and a failure of facts and reasonableness world. So it's a great time. This is the moment, if ever there was one, to push dispute boards and to push that whole human way of resolving disputes globally. Thank you very much for giving me that space to make a party political broadcast.
Thank you, Marian. And with that, I would like to thank each of our panelists for being here today with us to share their experience on dispute boards. And I would like to turn now to the organizers. I think I saw Ian Laird. The mic is yours, Ian. Thank you.
Well, thanks so much, Marjolise. It was a really enlightening panel. I've learned so much. This was a great group. I'm so pleased that we were able to get everyone together and share your views and your deep experience and knowledge about these issues. Hopefully, we can get some take up and at least a little more education about these alternative routes, particularly in the investment arbitration and investment context. There's absolutely more room for this type of thinking, and we very appreciate your views and coming today. It's takes a little bit of work, a little bit of time to organize these panels, but I think this has provided some valuable information to our listeners and viewers, and we'll have these discussions available on the website at some point in the future, and they should be a resource for folks who want to dive into these issues. So just to wrap up today's session, we are continuing on with World Arbitration Update. We have 2 more days. This is the end of day 4. And tomorrow, we're going to start off with a panel, which is bright and early Eastern time, 8 a.m., but in the afternoon, Madrid time, in the Europe time, on the ECT, and it's titled The ECT Investment Treaties in Europe and International Arbitration Awards Unfavorable to European States, Demystifying the Conundrum of International, Regional, European, and Domestic Law. And that looks to be a super interesting discussion and very timely one in light of all the goings on in the renewable energy sector and specifically with regard to the ECT. So I look forward to seeing everyone tomorrow. And thanks again to Marjolise and the entire panel. This was fantastic, and look forward to seeing everyone again tomorrow. Have a great night and a great afternoon.
Thank you.
Thank you. Have a nice day.
Thank you.